Okay, let's unpack this. Picture this scenario.
Oh.
You finally sign the lease for what seems like your dream apartment in California, maybe somewhere sunny in Orange County, or, a cool spot downtown.
Right, somewhere near the beach, maybe.
Exactly. And the landlord tells you, oh yeah, the building's history is spotless. Or they mention some great amenity, like a gym.
Sounds perfect until you move in.
Until you move in, and suddenly those assurances, well, they don't quite match reality.
It happens more often than you'd think. And that's why today, we're doing a deep dive into something really important for California tenants, especially if you're renting in Orange County, Riverside, San Diego, or Los Angeles.
What are we looking at?
Innocent misrepresentation.
Innocent misrepresentation. Okay. So we've looked into legal summaries, some academic stuff, even Wikipedia, to sort of figure out what this actually means for renters here.
Uh-huh. Our mission today is really to clarify what goes down when a landlord makes a false statement, but, and this is key, they genuinely believed it was true when they said it. How does that affect your lease?
And why should our listeners care? I mean, if it was an honest mistake.
Well, because even those honest mistakes, those unintentional slip-ups, can seriously mess with your decision to rent a place. They can cause real problems once you're settled in.
Right. So understanding this concept, innocent misrepresentation, it actually empowers you. It helps you know your rights and what you might be able to do about it.
Precisely. Knowledge is power, especially when navigating landlord-tenant issues.
So let's get specific. What is innocent misrepresentation when we're talking about a California lease?
Okay, so in simple terms, it's a false statement. It could be about a fact or even about the law made by the landlord or, importantly, their agent.
Like the property manager?
Exactly. Made to you, the tenant, usually while you're negotiating the lease. But here's the crucial part. The landlord honestly believes that statement is true when they make it.
So it's genuinely an honest mistake, not a lie.
Correct. It's not someone trying to deceive you on purpose. That's a different category altogether.
Okay, that distinction matters. Can you give us some real-world examples? Things tenants in, say, Orange County or LA might actually encounter?
Sure. Imagine a landlord says, nope, never had a pest problem here, truly believing it. But maybe there was a big issue a year before they bought the place.
And you move in and find roaches everywhere.
Right. Or they might say, yeah, that parking spot's included, but they forgot it's actually an extra $100 a month according to the building rules.
Ouch.
Or for someone renting commercially, maybe the landlord gives outdated info on what kind of business you're allowed to run there based on zoning. That could be devastating.
Okay, those make sense. Now, does the landlord have to actually say something wrong? What if they just don't mention something really important? Like they just keep quiet about the leaky roof?
That's a really good question.
Mm-hmm.
Generally, innocent misrepresentation involves a positive assertion, something said or written. Silence usually isn't enough on its own. Well, there's a catch. If they say something that's technically true, but they leave out a critical piece of information that makes the statement totally misleading, that omission could potentially count. It's about the overall impression.
Okay, what about opinions? If the landlord says, this is a really great neighborhood, super quiet, is that misrepresentation if it turns out to be noisy?
Generally, no. Statements of opinion usually aren't treated as misrepresentations of fact unless...
There's always an unless.
Right. Unless the landlord has some kind of special knowledge you don't have. Because they manage the building or know the area inside out, their opinion might imply a factual basis. It carries more weight then.
Makes sense. Their expert opinion isn't just casual chat. And this misrepresentation, it could be spoken, written down in an email, maybe even just implied by showing me something.
Absolutely. Spoken word, emails, the property listing itself, even their actions, like physically pointing to a storage unit and saying that one's yours, can imply it's part of the deal. And here's something else to keep in mind. What if a statement was true when they first said it, but then things change before you actually sign the lease?
Like, they said the pool will be open, but then it closes for major repairs.
Exactly. In some situations, the landlord might actually have a duty to update you if something they told you earlier is no longer true.
Okay, so the landlord makes an untrue statement, believing it's true. How does that actually impact me, the tenant, legally speaking?
Two key things here. First, that false statement has to have induced you to sign the lease.
Induced.
Meaning
you relied on it. It was a factor, maybe not the only factor, but a significant one in your decision to rent that specific place.
Do I have a responsibility to, check everything they say? Do I need to hire a private investigator before I sign a lease in Riverside?
No, generally the law doesn't expect you to do that. As a tenant, you're usually entitled to rely on what the landlord or their agent tells you.
But I feel a but coming. Well, yes. If you decide to do your own investigation into something they told you you independently verify the square footage or check zoning laws yourself, and you rely on your findings instead of their statement.
And I can't really claim I was misled by them later.
It could definitely weaken your claim, yes.
Yeah.
The focus is on what actually caused you to sign.
Okay, so false statement. I relied on it. It pushed me to sign. What else?
You also generally need to show you've suffered some kind of loss or detriment because you relied on that false information.
So it has to have actually harmed me somehow.
Yes. This could be financial loss, like paying for that non-existent gym access,
Oh.
or it could be other problems, like the disruption and cost of dealing with that undisclosed pest infestation. It needs to have had a negative impact.
Right. False statement, inducement, loss. Even if it was an honest mistake, what can I actually do about it then? Am I just stuck?
Not necessarily. The main legal tool for innocent misrepresentation is called rescission.
Rescission. Sounds legal. What does it mean?
Think of it like hitting the undo button on the lease. The goal is to put both you and the landlord back in the positions you're in before you ever sign the agreement.
Undo the lease. So I could potentially get out of it.
Exactly. Rescission could mean you're released from your obligations under the lease, no more future rent payments. And you might be able to get back rent you've already paid, plus your security deposit. It unwinds the whole deal.
Wow. Okay. Can I also get money for my trouble? Like compensation for the hassle or the extra costs I incurred? Damages.
That's where it gets a bit more complicated. Traditionally, for innocent misrepresentation, the main remedy was just rescission. Damages weren't typically part of the package.
Just unwinding it, not paying for the trouble caused by the mistake.
Right. However, legal ideas evolve. In some places, and California law has similar concepts, courts might award damages instead of rescission if simply undoing the contract isn't practical or totally fair anymore.
So maybe damages if rescission doesn't work well?
Kind of. But usually you can't get both rescission and those damages that are given in lieu of rescission. It's typically one or the other for innocent misrepresentation.
Okay, rescission sounds like a powerful option for a tenant stuck in a bad situation due to a landlord's mistake. But I'm guessing it's not automatic. Are there catches?
Yes, definitely. Your right to rescind isn't absolute. There are several things that can limit or even eliminate that right.
Like what? What could stop me from rescinding?
Okay, first up is affirmation. If you find out about the misrepresentation, but then you act like you want to continue with the lease anyway.
Like I find out the gym isn't included, but I just keep paying rent for months without saying anything.
Exactly. If you act in a way that signals you're okay with the lease despite the issue, you might be seen as having affirmed the contract, and you could lose the right to back out later.
So, acting quickly is important. What else?
Delay. Similar idea. If you wait too long after discovering the misrepresentation before you try to rescind, the court might say you waited too long. There isn't a hard deadline. It depends on the circumstances.
Okay, don't sit on your rights.
Yeah.
Got it. What if things have just changed a lot since the lease started?
That brings us to the impossibility of restitution. If things are so different now that you can't realistically put everyone back to their starting positions.
Like maybe I've lived there a long time and made major changes to the apartment.
Precisely. If it's impossible to truly undo the situation, rescission might not be granted. Although, like we said, sometimes courts might order monetary adjustments instead to try and be fair.
What if the landlord sold the building after I moved in?
Good point. That involves third-party rights. If the property now belongs to someone else who bought it in good faith, unaware of the original misrepresentation, courts are usually hesitant to grant rescission if it harms that innocent new owner.
Right, that makes sense. One last thing. What about the lease itself? You know how they have all that fine print? Can landlords just put in a clause saying they're not responsible for anything they said before signing?
Ah, yes. Exclusion clauses. Landlords definitely try this. You might see an entire agreement clause saying only the written lease matters, or a non-reliance clause where you state you didn't rely on any prior statements.
And do those work? Can they just contract out of responsibility for mistakes?
It depends. The effectiveness hinges on the specific wording and whether California law considers that clause fair and enforceable in your situation. But, and this is critical, a landlord can never use a clause to get out of fraudulent misrepresentation. If they lied intentionally, no clause can protect them.
That's really important to know.
Absolutely. And if you're facing issues with lease clauses or potential misrepresentation, especially concerning eviction or other tenant matters in Orange County, Riverside, San Diego, or LA, getting advice from legal professionals who only represent tenants, like MartinezLawCenter.com, can be crucial. They understand these nuances from the tenant's perspective.
You mentioned fraudulent misrepresentation just now, and earlier you touched on different types. Why is knowing the difference between innocent, negligent, and fraudulent misrepresentation so vital for a tenant?
It's absolutely vital because the remedies, what you can actually get, change significantly depending on the type. It dictates your legal options.
Okay, break it down for us. What are the key differences in the outcomes?
Sure, let's start with the worst. Fraudulent misrepresentation. Here, the landlord knows the statement is false, or they say it recklessly without caring if it's true, and they intend for you to rely on it.
They're deliberately trying to trick you.
Exactly. Because it's intentional deception, the remedies are stronger. You can usually seek both rescission, getting out of the lease, and damages for all the direct losses caused by the fraud.
Okay, both options potentially. What about negligent?
Negligent misrepresentation is kind of in the middle. The landlord makes a false statement, but maybe not intentionally lying. They were just careless. They didn't have reasonable grounds to believe it was true when they said it.
So, not malicious, just sloppy.
Pretty much. In this case, you can typically seek both rescission and damages to cover your losses resulting from their carelessness.
And that brings us back full circle to innocent misrepresentation.
Right, where the landlord made the false statement but genuinely honestly believed it was true. Here, as we've discussed, the primary remedy is rescission undoing the contract. Damages are less common, maybe only in lieu of rescission sometimes.
So the landlord's state of mind, were they lying, careless, or honestly mistaken, is the absolute key.
That's the core difference. It determines everything about the potential remedies available to you as the tenant.
Okay, this is incredibly helpful. So let's talk practical steps. For tenants listening in California, especially those in Orange County, Riverside, San Diego, LA, what should they be doing?
Number one piece of advice: be thorough before you sign. Investigate claims made by the landlord or their agent, especially the important ones. Ask questions.
And document everything.
Document absolutely everything. Keep copies of emails, notes from conversations, the listing, any written promises. Proof is essential later if issues arise.
What else should tenants keep in mind?
Ask yourself those key questions about any statement that feels off. Was this presented as a fact? Did it genuinely influence my decision to rent this place? And crucially, have I actually suffered some kind of loss or harm because it wasn't true?
Thinking through those points helps clarify the situation.
It does. And remember, if you are a tenant in these areas, Orange County, Riverside, San Diego, Los Angeles, and you're dealing with complex issues like eviction defense, unlawful detainer actions, property disputes like partitions, or even accidents due to premises liability in your apartment, MartinezLawCenter.com specializes in representing tenants and renters only.
What if you only discover the problem after you've moved in and signed the lease?
The moment you suspect a misrepresentation, act quickly. Don't just hope it goes away.
Why the rush?
Because, as we mentioned, delay can jeopardize your right to rescind. Seek legal advice promptly to understand your options based on your specific situation. Understand that rescission is often the main path forward for innocent misrepresentation.
And be wary of those lease clauses.
Yes. Be aware that landlords might try to limit their liability through the lease. If you have concerns about what your lease says or about a potential misrepresentation, getting professional advice is key. Again, for tenants needing guidance in Southern California, MartinezLawCenter.com is a resource focused solely on tenant rights.
This has been a really insightful deep dive. So if we boil it all down, what's the main takeaway for tenants listening today?
I think the key takeaway is this. Even though innocent misrepresentation involves an honest mistake by the landlord, it can still have very real, very significant legal consequences for you, the tenant. Understanding that you might have the right to rescind the lease to undo it, and knowing the limits around that right is crucial knowledge to have.
And it underscores the importance of resources tailored to tenants.
Absolutely. Especially when dealing with issues like eviction or unlawful detainer in places like Orange County or LA, having representation that only advocates for tenants like MartinezLawCenter.com is invaluable.
And maybe a final thought for our listeners to chew on. In today's world, with information supposedly everywhere, where does the responsibility really lie for ensuring statements made before signing a lease are accurate? Is it more on the landlord, who knows the property, or the tenant to verify everything?
That's a great question. Is the current legal balance, focusing primarily on rescission for innocent mistakes, truly fair? Or should tenants perhaps have more pathways to get compensated for the real trouble and harm caused, even by unintentional errors?
Something to definitely think about. The balance between landlord responsibilities and tenant due diligence.
It's a constant balancing act in landlord-tenant law.
So, if you think you might have been affected by any type of misrepresentation in your California lease, innocent, negligent, or fraudulent, especially if you're renting in Orange County, Riverside, San Diego, or Los Angeles, the clear message is don't wait.
Don't wait. Seek legal advice to understand your specific rights and options.
And for more information tailored to tenant rights in these areas, you can visit martinezlawcenter.com.
Call now 714-442-9741. Thank you.